So to answer all those questions and to talk particularly about this issue of strategic litigation, which is the subject for tonight, we've got a great panel. I'm going to hand over first to our first speaker, which is Nick Grono, the CEO of Freedom Fund. The Freedom Fund has got a landmark publication now, as I know many of you will already have read, Ending Impunity and Securing Justice. This is a critical piece of investigation and analysis that allows us to talk directly to this. So, Nick, without further ado, over to you.
Thanks, Phil. So lots of questions you've posed there. I'm going to start with a threshold question, which is, when is litigation strategic? Now, for some skeptics, and I'm sure governments out there and some corporates, they would say never. But that's not really an answer to the question. Framed another way, the question is, what's the difference between ordinary litigation and where one party sues another party to remedy an alleged wrong, and strategic litigation? And to my mind, the difference between ordinary litigation and strategic litigation is in the impact that's being sought in bringing the litigation. Strategic litigation, in fact, is often called impact litigation. Right? It's focused on what's the impact you're trying to achieve. And the objective is not to simply remedy an individual wrong, but to bring about a change in policy or law or public awareness that benefits a larger group beyond, in addition to the litigant in question. And it's about using the law as a tool to drive wider policy or social change. And for the purpose of today's discussion, the purpose of strategic litigation is to change for the better the way companies react and respond to the presence of slavery and forced labour in their supply chains. And this is not a new concept. I mean, this is what's so interesting in the modern slavery space. We're not dealing with a new concept. I mean, strategic litigation was used as a powerful tool 200 years ago. The 18th century British abolitionists pioneered the use of strategic litigation to drive really important social and legal change. And they used litigation very skillfully to bring an end to the transatlantic slave trade. There was an 18th century abolitionist called Granville Sharp who kind of used the law to advance their agenda. And there was a particular case that I just want to talk about briefly, because it's so interesting, called Somerset's case, where there was a slave who was brought from Jamaica to England, escaped in England. He was on the run for a couple of months, grabbed, seized by those that purported to own him, stuck on a boat which they wanted to rush back to Jamaica. Granville Sharp heard about this and brought proceedings before the Lord Chief Justice, Lord Mansfield, seeking an order that he couldn't be returned to Jamaica. Now, this was a really problematic issue for the courts. They were stuck between a rock and a hard place as far as they were concerned. There was this issue of slavery, and then there were these very powerful rights and what was perceived as the law of the land. But after many months, Lord Mansfield decided that, and he ruled that a master had no right to force an enslaved person to return to a foreign country. And this James Somerset was freed. Now, the actual case in question was deciding a fairly narrow point, but it was actually interpreted as deciding that slavery was practically illegal on English soil. So it had a much broader impact than the particular outcome, which was the freedom of James Somerset. And to my mind, well, first of all, it was one of the big successes of the abolitionist movement, but it was also an illustration that strategic litigation doesn't exist in a vacuum. And if there's one message I think that I want to convey around strategic litigation, is it's a tool, and it's one of many tools that is used to achieve the change that you're seeking to achieve. With the abolitionists, they wanted to change the law, the policy, public awareness, and very, very powerful, they challenged very, very powerful economic interests. And it's interesting, and again, at the risk of kind of giving a historical lesson instead of talking about modern day slavery, the way they went around this, I think, holds really powerful lessons. Beyond Granville Sharp, there was a leading abolitionist, Thomas Clarkson, who pioneered many of the tools that we use today to drive the change that we're seeking to achieve. Clarkson and his band of abolitionists pioneered investigative reports, investigative journalism, letter writing campaigns, consumer boycotts. They founded what was the precursor of the world's oldest human rights organisation, which still exists today and I think is represented here, Anti-Slavery International, one of our partners. And so to their mind, litigation was one of the panoply of tools to achieve powerful change. And they were successful, remarkably, in achieving legal abolition of the transatlantic transatlantic slave trade by 1807. And if you kind of put your minds in that situation and think of what they were trying to achieve at a time in the 1770s where slavery was just accepted as a concept, where there were hugely powerful vested economic interests and social interests in support of slavery, and to use all of these tools to achieve change, I think is a powerful demonstration of what can be achieved. But of course, that's 250 years ago, and the challenge is the fact that even though they were very successful in the formal legal abolition of the transatlantic slave trade, modern slavery still exists today. We call it modern slavery, contemporary slavery, to kind of distinguish it from different forms of slavery. But the substance is very much the same. You know, the substance of slavery, as it was with chattel slavery, where people were locked up in chains and conveyed to their workplace, is that it's the control of individuals through violence and other forms of coercion in order to force them to work. That's the core of slavery. So a fisherman who's trapped on a Thai fishing boat, forced to work on a Thai fishing boat for 2 years at end, subject to horrific violence, not paid, is enslaved. And he's enslaved to produce seafood that ends up on our supermarket shelves. Nepali workers were brought to World Cup construction sites in Qatar, and they're indebted, they're forced through this debt and threats of violence to work in unbearable conditions, not paid or hardly paid, they're enslaved. Children forced to work in the mines in the Congo that produce the minerals that end up in our mobile phones. Forced labour, modern day slavery. We're going to see litigation on this. Right? We're going to see litigation against construction companies in Qatar. We're going to see litigation against companies that have slavery in their seafood supply chains from Thailand. There's already been unsuccessful consumer-based litigation against Nestle, Mars, and Costco in the US around seafood and slavery, but there will be more. And the purpose of this litigation is going to be to provide recognition to the victims, but it's also going to be to change the calculation of the corporates. And I think this is really important to understand. You know, slavery exists in these extended supply chains. There's a cost to businesses in cleaning up their supply chains. Right? Labour exploitation lowers business costs because you aren't paying your workers anything, or you're paying them substantially reduced wages. And it costs money to stand this out when you're operating in multiple jurisdictions, in places where it's very hard often to get access. There is a cost to doing this. Even well-meaning companies will not necessarily prioritise efforts to stamp out slavery and forced labour in their supply chains. The purpose of litigation is to change that cost-benefit analysis, one of the tools to change that cost-benefit analysis. But it's not easy. It can be very expensive. I mean, you're talking about representing marginalised, vulnerable workers in places like Thailand or Qatar against often powerful corporations. It requires a real investment. It requires an understanding that the objective is often bigger than winning the case itself. So my organisation, the Freedom Fund, published a report on strategic litigation in December, which we launched at Lee Day, in partnership with other organisations working on the issue. In that report, we outlined a number of key elements to underpin litigation. I'll just list them here, and we can come back to them in the question and answer if there's any interest in discussing them further. But what we said for successful international transnational litigation, strategic litigation, key elements include identifying key defendants and target locations for strategic litigation. 2, research the law and legal system in the country of abuse. 3, build relationships and communities of survivors and potential litigants and local NGOs. 4, collect intelligence through investigative reporting, coverage, and conduct due diligence. 5, establish and support skilled litigation and advocacy teams. 6, build budgets and identify funding sources to support litigation efforts. 7, support regional umbrella NGOs to encourage local activism and litigation to build on the cases you're bringing. And 8, develop powerful advocacy strategies to press for enforcement of court decisions. That report's online, it's on our website, there are some copies here, so you don't have to make a list of all of these. But the final point I want to end up on is that it's also worth bearing in mind strategic litigation can succeed even when the case itself does not. You know, given that the attitude is to change, given that the objective is to change attitudes, a powerful case can air issues and bring to the public attention the atrocities of modern day slavery, even if the case itself ends up failing on technical or substantive grounds or ends up being settled. And as that great abolitionist William Wilberforce observed, you may choose to look the other way, but you can never say again that you did not know. And I think that's very powerful impact indeed. Thank you very much.